Good morning, counsel. This is the time set for oral argument in 1 CV160217 Ryan versus Henry. Counsel, each side is allotted 20 minutes for argument. Appellant may reserve a portion of that time for rebuttal. If you wish to do so, counsel, then we can keep track of that time using the podium clock. Out of respect for counsel and the court, I ask that those in attendance please make sure your cell phones are on vibrate or off. Counsel, I can let you both know that we have read your briefs. We conferenced the case just this morning, and we encourage you to keep that in mind as you present your oral argument to the court this morning. These proceedings are being recorded, and they will be posted to YouTube. So before you begin your argument, please state your name and the party that you represent. With that, we will start with the appellant's counsel, Ms. Wilkins.
May it please the court. My name is Amy Wilkins, and I'm here on behalf of appellants Pauline and George Henry. I'd like to reserve 2 minutes for a rebuttal. We're here today on two issues. First, did the trial court err in upholding a verdict that found an oral partnership agreement could dictate the members and directors of an existing Arizona nonprofit corporation? Second, did the trial court err in awarding fees when this case did not arise out of contract? An absent direction from the court, I'm going to start with the first issue. This court should reverse as a matter of law. A partnership cannot control who the members and directors of an Arizona nonprofit corporation are. Once the corporation is formed, then Arizona statutes control how additional directors can be added and how members can be added.
All right, Ms. Wilkins, I understand your argument when you're saying that was contrary to law, but didn't your clients agree that the jury was to be tasked specifically with deciding who the members and the directors of Absolute were?
The jury could determine the terms of the joint venture agreement and we submitted an alternative verdict form that had a different result. But once the jury came back with a result that was contrary to law, we did file or do an oral Rule 50A motion and
How is it contrary to law? I mean, like I said, in your joint pretrial statement, your stipulated order, and the jury verdict forms, the way I read the record, that the parties agreed that the jury was to be tasked specifically with those deciding those issues.
I believe that the jury was tasked with deciding the terms of this purported oral joint venture agreement, but as Mr. Wilenchek argued to the judge, once the evidence was presented, you can't have this oral partnership agreement that sort of floats beside the corporation and then dictates who the members and directors are. And I understand the court understands the argument, but I would like to just go over the history of this because this isn't a case, and I thought about this issue a lot, where you have a joint venture to form a corporation. And I think that's a different case because here we have a partnership that's existing side by side along with the corporation. It wasn't three members have a joint venture and then go decide to form a corporation. It wasn't formed properly. Absolute was formed in May 2011 with the help of an attorney. And it was Pauline and George Henry along with Mr. Hammer and Mr. Hale. Mr. Ryan was not on the scene yet. Almost a year later, they went back to Ms. Farakis and amended the articles. And the first articles had Pauline and George Henry as directors and not the others. 10 months later, they amend the articles, not to change the directors, but to change the name. At the same time, these four people agree to bylaws that say there won't be any members. So we're 10 months later.
Even in the articles saying that there are members.
That's correct. The articles do say there are members, and then the bylaws that were introduced that, with the help of an attorney, that all four of these parties had used as their attorney, agree to bylaws that say no members.
But the articles control.
The articles do control, yes, but I think the remedy there is not to ask a jury, well then who are these members?
That's specifically what was asked in how the issue was framed to the jury to decide. Isn't that correct?
I think that if the jury was tasked with deciding that question, but yet that is a result that's contrary to law. The trial court still had a duty to grant our Rule 50 motion.
It just seems odd that you agree that a jury should decide an issue, and if an issue is decided in the way that you would rather not be decided, you say that's contrary to law. That doesn't quite make sense to me.
I understand. I think that one of the things that happened in this case that's a little unusual is that because plaintiffs never brought a contract claim, and there was a reason for that, there was a statute of frauds issue. I'm trying to answer your question as quickly as I can. The joint venture agreement theory did not come up until summary judgment, oral argument on summary judgment 2 months before trial. So there's a limited amount of time for objections to the makeup to be raised.
Well, your answer raises two questions for me. Now I'll ask a short one first. The joint venture agreement is an agreement. It is a form of a contract, correct?
I would actually disagree with that proposition, and I base this on plaintiffs' own argument when they were arguing jury instructions, when they were opposing our contract instructions and said, no, a joint venture is a form of partnership law, not contract law. So while their own argument was that while a joint venture does have part of it as an agreement, it's governed by the laws of partnership and fiduciary duty, that sort of thing.
Does that mean it's not a contract, though?
Yeah. That doesn't make sense to me.
We sign a joint venture agreement where I agree to do something, you agree to do something. Isn't that a contract?
I think it is, yes. I think that whether or not the duties arise out of the joint venture, which is part of my fee argument, which I won't jump into right now, would be governed by partnership. You could also alternatively make a breach of contract claim if your joint venture agreement were breached. They never did that here.
My other question is, if you have asked the jury to make a particular determination, whether you believe that is a correct determination or not, it just seems wrong or not proper for you to be complaining about the very thing that you asked the jury to decide.
Yeah, I see Your Honor's point. I think, though, that the jury cannot make a determination of law other than as an advisory jury.
Well, then you should have asked the jury to decide that.
But I don't know that you can waive turning over a legal issue to a jury when it's properly raised in the middle of trial and said, this can't be the law, judge. This can't be it. So that's our argument.
Thank you.
I just want to briefly address the articles and bylaws issue as well, because there was that issue. The article said there shall be members, and the bylaws said no members. And I believe Appley's argument on that point was, well, therefore, you have to pick who the members are. And I respectfully submit that that's not how it works. So if you had a different case where there weren't people clamoring to be members and directors, you wouldn't just ask the jury to arbitrarily pick some members. You would go back to the board and say, fix your corporation. Either amend your bylaws, amend your articles, or do something, but that would be the proper result here, not just, okay, go find some members.
You don't have a functioning board here to do that, and if you told the jurors to look at the joint venture agreement and decide whether that is dispositive as to who should be members, why isn't that a reasonable way to approach it?
I think we did have a functioning board. The initial board was the Henrys, Pauline and George, and because they were permitted to add additional board members, they had done so. So there was a 6-member board actually at the time. And as to your other question, I've answered it the best I can as far as we did object in the Rule 50 motion. Before I turn to fees, one last point on the joint venture agreement. When you look at what is the joint venture agreement, and we raise this in the brief, there's two problems with it, and it's, well, really it's the same problem. It's the sharing of profits and losses. Once you have corporate forms, PNTM is an LLC, and they had how they were going to share losses or profits, and it wasn't equally. 37.5% to Mr. Ryan, 42.5% to Ms. Henry, the remainder between Mr. Hammer and Mr. Hale. And obviously, once you have a corporation, losses aren't borne by the partnership, they're borne by the corporation. Maybe indirectly to the members and shareholders, but there's a corporate form for that reason. And likewise, a nonprofit can't have an equal sharing of profits because of the non-distribution requirement. I'd like to turn now to fees, unless you have any further questions for me. This court should reverse the trial court's ruling on fees because the fees didn't arise out of contract as required by ARS 12-34101.
But, Ms. Wilkins, didn't your clients seek fees under that very statute in your answer and counterclaim?
We did.
So what's not good for the goose is it great for the gander type of thing? Or I don't understand your argument if you're saying that it didn't arise out of contract, but yet below you sought for fees under that very statute, 12-34101. I don't see how that's consistent with your argument here before this court.
Well, obviously my side did not prevail, so we didn't have a chance to actually apply for fees, but I would say that I'm going to adopt one of Appleby's arguments right now, that you aren't confined by the pleadings, but on how the case evolves as it goes through to trial, with the joint pretrial statement and the actual what issues were tried by the court. And what issues were tried by the court weren't a breach of contract case.
Well, isn't you asked for fees under the statute, you would implicitly believe they're contract claims?
Yeah, at the time, at filing the answer, counsel must have believed that there was a basis to ask for those fees. As the case evolved and it became based on an oral joint partnership agreement.
And you can really switch positions in the middle, can you?
I think that you could ask for fees if the claims asserted at the time supported fees, but if the case evolved and say your contract claim got dismissed on summary judgment, you wouldn't be bound by that.
There's no contract claim. I mean, you've said that this is a case that arose by virtue from an agreement. Doesn't that translate to it's a claim that arises under contract? Do you necessarily have to have a breach of contract claim?
No, you don't. You don't. And that's why I would encourage the court to turn to the tests that have already been established. Not whether or not the word, say, promise was used in the complaint, but could plaintiffs have brought these claims absent a contract? Do the claims exist but for a contract? And here they do. Plaintiffs obviously thought so because they did not put it in their complaint. And
Do they exist but for the agreement among the parties, the initial agreement?
Well, I think that if you look at the initial agreement as a contract, here's where they didn't bring it as a contract. I'm not trying to duck your question, but there was a statute of frauds problem because one of the claims we're not really debating in this appeal is whether or not the LLC was the perpetual exclusive management company, and that was a statute of frauds issue. So they very carefully didn't plead a contract claim. Now, I would say they still, to directly answer your question, have claims that don't arise out of contract if you look at the joint venture agreement as a creature of partnership law. There you would still have fiduciary duty. So if four people had a partnership to go form a corporation and it wasn't formed properly, you could say, well, you're my partner. You got a fiduciary duty to me. So the claims that are breached here arise more out of that than any promise, especially the way it was pled.
Well, I have another question of what happened regarding what happened below. When you stipulated the counterclaims would be dismissed, I think they were counts 4 through 10. I believe and I'll ask this question, Mr. Frazier. I believe you stipulated that Ryan would be the prevailing party and could seek attorney's fees, costs, and sanctions. Is that correct?
That was part of the stipulation, and the way I read that is you can apply for fees, but they still have to be reasonable. They still have to be statutorily based or allowed. It was just part of a stipulation to release some claims.
And are you claiming now that the fees that were awarded were unreasonable?
Yes.
Okay, where can I find that in your brief?
We did a very succinct job of it in our briefing, Your Honor. Definitely, we gave some examples of some unfairness. What we are really hinging our hat on is there was extensive briefing on it for the trial court with pretty concrete examples of unreasonable fee entries. For example, in our reply brief, we put in the one where 0.7, I think, was billed for reading a joke email. And entries that didn't have anything to do with this litigation. But the trial court just found they were reasonable and awarded it. And we would like remand for someone to actually review this and determine the reasonableness of these fees.
Okay, and those unreasonable attorney's fees and costs were, you say, succinctly captured in your briefing, so I can find it. If I go back, I can find those arguments in your briefing.
Our briefing, I admit, was very, very brief on this issue. And again, we just asked the court to look at the overall picture of the trial court denied it despite extensive briefing in the trial court on this issue.
Thank you, Counsel.
So you did highlight in the trial court, you're saying the entries that you pointed out in the reply?
Very thoroughly, Your Honor. All right. I think that I've covered my main points, so I have 4 minutes left. I think I'll reserve those for a rebuttal.
All right.
Thank you.
Thank you, Counsel. Mr. Frazier, when you're ready.
Excuse me. Good morning, Your Honors. May it please the Court. Eric Frazier on behalf of the plaintiffs, Nolan Ryan, Tim Hammer, and Mark Hale. This Court seems to have it exactly right, that this argument was waived below. And we can start from the verdict forms. It was waived a number of times, but the verdict forms are a really good example. Because not only did the defendants not ask the court to take this away from the jury, and not only did they agree that this should be a jury trial, and not only did they submit verdict forms that presuppose that the jury would be deciding the issue of members, but if you look at their verdict form on members, it doesn't even say what the defendants are now raising on appeal, which is that there are no members. The defendant's proposed verdict form in the joint pretrial statement asks the jury to determine that the members are Pauline Henry and George Henry. If their position below was the same as their position on appeal, that verdict form would, well, first of all, the verdict form wouldn't exist. And second, even if it did exist, it wouldn't ask the jury to find that there are members. And third, even if it did, it wouldn't list Pauline and George. It would ask the jury to say that there are no members. So this was...
There would seem to be a legal, it would seem to, in a construct, there seems to be a legal issue that would preclude what the jurors are asked to consider, correct?
Well, no, but first of all, even if it...
If she is correct that it is a question of law, then the issue would never reach the jury, correct?
If we assume that this is a question of law, then she should have raised this long before.
Right.
So you can't have a jury trial and then say it's a question of law.
Right.
You need to say so before, in the joint pretrial statement, before it gets to the jury.
And that didn't happen.
That never happened. And this issue was not even squarely raised in the Rule 50A motion. In the reply brief, defense counsel pointed out to a couple of times when Dennis Willencheck, the trial counsel, made some statements in the Rule 50A motion that out of context, suggests that maybe this was being raised. But in fact, what Mr. Willinchuk was arguing, when you read it in context, his whole argument on the Rule 50A motion was on the loss sharing requirement. He was not asking the court to take this overall issue away from the jury, and he did not ask the court to rule that the jury could not conclude who the members and the directors were. At bottom, Your Honors, this is a case about a group of people who wanted to work together, and they made agreements to share everything equally. They agreed to form a not-for-profit, and they agreed on who the members and directors would be. That's a question you can ask the jury to decide, because what the jury found and what the judgment shows does not conflict with any statute or any controlling document. So the whole premise of the defendant's theory is just wrong. It doesn't conflict with the not-for-profit statutes, because the not-for-profit statutes say the Articles of Incorporation specify whether there are members. And once you get there, under Arizona law, the bylaws can't trump that. So then you're just left with the question of, okay, the corporation has members. Who are those members? And that's a question that you can come to the court to resolve. You can say, we made an agreement about who the members would be, and you can ask the court to resolve that dispute, that disagreement, just like you can ask the court to resolve any other type of dispute. Now I'd like to...
Could a third party come in to do the same thing if someone were seeking to impose liability on the corporation? Could it come in and say, I think these other people are also members, they had some sort of agreement?
I'm not sure that person would have standing to ask the court to resolve that agreement. No, I'm not sure that person would have standing. I'd like to just make a couple of quick points on loss sharing before I turn to fees. Again, what the defendant's argument really boils down to is a notion that you can never have a joint venture agreement that has a not-for-profit component. And that's just not the law. That can't be the law. The loss sharing requirement doesn't ask the court to determine whether the endeavor will have profits or losses. It asks the court to determine if there are profits and losses, will they be shared among the parties. Now on fees, I'd like to start with the sarcastic line item in the fees. Now that was raised for the first time in the reply brief, so we haven't had a chance to brief it to the court. So I'd like to give the court a citation because I encourage you to look at the line item in context. It's an index of record 656, and that's at PDF page 35. So IR 656, and it doesn't have sequential page numbering, so you'll just have to look for the PDF page 35. So the entry that the defendants have pointed out is clearly sarcastic. I'm not going to defend that. But if you look at it in context, here's what's actually going on. The time entry for that date that the defendants have pointed out in the reply brief has two sets of time in it. It has serious time entries for real work performed that add up to 1.9 hours. And then it has sarcastic entries that add up to 0.7 hours. That's what defense counsel just told you. And if you look at the spreadsheet in context, it's a little unusual, but there's, on the right-hand column, it lists the time entries for every day. And this lawyer listed two time entries for most days. He listed a time entry on the left, or a number on the left, which shows the billed time, and a number on the right, which shows the unbilled time. He sometimes uses the abbreviation WD for write down. That's really important because it shows that for this time entry, the 1.9 hours of real time was billed to the client and was included in the Superior Court's fee award. But the 0.7 hours for this joke email was never billed to the client. It was included in the time entry and then immediately written off right to the right. So that means that joke time was never billed to the client and was never included in the Superior Court's fee award. That just shows why appellate courts affirm fee awards if there is any basis in the record, because the trial court had the opportunity to look at these squabbles about time entries. The trial court had the opportunity to go line by line and determine whether particular entries were fee eligible. So the trial court, likewise, is in the best position to determine the overall character of the claims in the case. The trial court saw how the claims evolved, how the claims were tried, It looked at how the claims were actually presented to the court rather than just the technicalities of how they were pled. So the court had broad discretion to award fees. The defendants...
Counsel, how do you respond to Henry's argument that your claims could be maintained in the absence of contract if the counterclaims rose out of tort activity, therefore the attorney's fees aren't recoverable under 34101?
Particularly on the counterclaims, Your Honor?
Yes.
So the counterclaims all arose out of contract under 12-34101 because 12-34101 is broader than just breach of contract claims. So it includes tort claims that depend on the existence of a contract. It includes seeking to invalidate a contract. It includes seeking to enforce the terms of an agreement through equitable relief and also interwoven and interrelated claims. So all of the counterclaims fall into those categories. Of course, the declaratory judgment counterclaim is a mirror image of our claim, which is really, what does this agreement look like about who the members and directors are? The accounting claim ordinarily might just be a non-contract type claim, but here the specific agreement that the parties are seeking to enforce includes a requirement for accounting. So that claim too, that counterclaim too, arises out of contract. The unjust enrichment counterclaim, for example, is the defendant or a counterclaimant, Pauline Henry, seeking to recover $500,000 that she invested with another entity, Mr. Pollock from his company THC. And that too is based on an agreement. If there were no contract, if there were no agreement about giving this money, how the money would be spent and how the money would be recovered, there would be no claim. So all of these claims, including the counterclaims, arise out of contract, and 12-34101 is broader than just breach of contract claims. If you have no further questions, Your Honors, we ask that you affirm the judgment.
Could I just go back to my question that I'm not sure where it leads, if anywhere. But you can have an agreement that, what's the point of listing members and directors if you can just have a separate agreement that's inconsistent with the people who are listed? Is that, I'm taking it that that's their argument, that you can't just have a separate agreement that ignores the formalities that are required.
You can't have a separate agreement that conflicts with the formalities that are required. That's right. But you can have a separate agreement that does not conflict with the formalities. So you can imagine a wide range of hypothetical situations, some of which actually conflict with either the statutes or the controlling documents, some of which do not.
So you're saying it doesn't conflict with any statute to just list one member and director when in fact there are 10?
No. Well, so what we ask the court to do is determine who the members and directors are, and then you will correct the list. But nothing, there was no list here that was in any way binding on anybody, because again, this all stems from the perspective that there have to be members, and because the bylaws didn't specify who the members were, the court has to determine who those members are, and they can look at the parties' agreements, the parties' intentions, the course of conduct. If the bylaws had set forth requirements for how you select members and who those members are, maybe that would conflict, and but that would be an entirely different case. Here, because the bylaws didn't specify that there were members and didn't specify who those members would be, it's left to the court to fill it in and figure out what the parties intended to do. But you can always have these types of agreements among the founding members, among the directors. These types of agreements are common. Directors give each other proxies to vote. The directors or the members can make a side agreement to agree for it. The members, for example, can make a side agreement to agree on who they're going to elect as directors. And that agreement, that contract, is enforceable by a court. Even if it's not in the bylaws, even if it's not in the Articles of Incorporation, those types of agreements are enforceable by the court as long as they don't conflict with the statutes or the controlling documents.
But if someone, I guess my initial question was, if someone else wants to come in and impose liability on someone who has an agreement but just doesn't want their name on it, you're saying that person doesn't have standing, that the contract doesn't mean anything necessarily in that context if it's a third person who wants to come in and impose liability?
That's an interesting question. I haven't thought about that before, but again, I think it comes down to standing. I'm not sure how that third party would have standing to enforce the contract that it controls the makeup of the membership or the board. If you have no further questions, we ask that you affirm. Thank you.
Thank you, counsel. Ms. Wilkins.
Thank you. I'd like to start with Judge Gattani's question about this third person who wants to come in, and that's been addressed twice by this court, and that would be the Kahn case and the Vortex case, in which there were people trying to assert, I'm a member or director of this corporation, and this court has twice said, no, for example, in the Kahn case, maybe you had some understanding that you were going to be a member of this LLC, but nobody did anything alongside the corporate formalities to make that happen. So because there was an existing form, you can't just come in and say, I have an agreement to be a member.
So in your view, a third party couldn't come in and seek to impose liability on someone based on a separate agreement?
I think that you have to look at what that agreement is. I think that there could be a case where you could have an agreement, I'm going to invest money, and in exchange I'm going to be a member. That's probably what Mr. Ryan did with PNTM. I invest some money, I get a 37.5% membership. But the idea of this side partnership having secret members and directors is so contrary to our understanding of how Arizona corporate law works. That is why this agreement, which apparently existed for years beside these existing formed corporations, just can't be legal, can't be enforced. That's really the only point I wanted to address on rebuttal. I thank you all. Unless you have any other questions for me, I thank you all very much for your time today.
Thank you, counsel. Thank you both for your briefs and your presentation. Both were very well done. We'll take the matter under advisement and issue a written order in due course. The court will now stand adjourned. Thank you.